our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, we're talking about the top 10 mistakes real estate investors make when raising private capital. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like. You can find us on YouTube, Facebook, and you can find us on X, formerly known as Twitter. Make sure to subscribe to the channels. You can find us at the handle @InRem Podcast. That is @InRem Podcast. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is a little unique. Mostly I'm focusing on real estate-based legal issues, creative financing legal issues. But today I'm going to go a little off script, off topic, and still talk about, some legal issues, but it has nothing to do with real estate. My legal update today is, what do you do if you're in an accident? So our firm, in addition to our real estate transaction litigation practices, we also have a personal injury department and practice where we represent accident victims in their personal injury cases. And so we see a lot of our clients come to us after an accident, and we find out what they did, what they said, different things, and we realize, if only we had been your attorney before the accident and had given you this advice, we wouldn't be dealing with certain issues that we're now having to deal with. So I know this show is for real estate investors, many of whom are out there, driving around a lot, checking on properties, maybe, driving around, going door to door, different things. And the more you drive, the more likely it is that you're in an accident. And the more you drive, the more likely it is that the accident is somebody else's fault. And so what happens if you are out there driving around and all of a sudden, somebody makes a mistake on the road and causes an accident and injures you? They damage your car, and they potentially cause you, some type of personal injury as a result of the accident. What do you do? So the first thing that you're going to want to do is you're going to want to call the authorities. And you can say, well, it was just a minor, collision. Why do we need to get the police involved? Well, two reasons. So first, just because it's a minor collision doesn't mean that you're not going to feel the effects of the accident a day or two later. Many times our clients are in accidents. They think they're fine at the accident scene. They exchange paperwork, and then the next day they wake up, very sore, and they, don't realize that was going to happen, that they are going to need medical attention and care. And all of a sudden now they have a, potential personal injury claim. The second reason is you want to document exactly what happened at the accident scene. Unfortunately, we have situations where we receive these cases, no police report was filed, the law enforcement wasn't called. They just exchanged information. And of course, our client thought that everybody was going to be honest in the process. And we go through, we work up the file, we send a demand letter, only to have the insurance company say, hey, we're not going to pay a dime because we're not liable. Our insured is not liable, even though they're the ones that caused the accident. And the reason why they're saying that is because now their insured is lying about the accident and the cause, and there is no police report in the file. So now it's our client's word against theirs, and we have an issue on our hands. So call law enforcement. That's the first thing. The second thing that you're going to want to do is, if it's not your fault, you're going to receive the insurance company or insurance information from the at-fault driver's possession, and you're going to want to keep that. And then you're going to want to notify that insurance company that you've been in an accident. But when you notify them, they're going to say, well, why don't you give us a statement? You're not going to give them a statement. You're simply going to say, your insured was at fault. I'm not required to give a statement, but I do need my vehicle fixed. And so you're going to tender that claim to that third-party company, that third-party insurance carrier, and have them fix your vehicle. Don't place the claim with your personal insurance company. You can notify them of the accident, but don't have them fix your vehicle, because you're going to pay a deductible that you're probably never going to get back. Instead, you want to go straight to the other driver's insurance company and have them fix your vehicle. Then the third thing is, you do want to seek medical treatment if you feel any type of tightness, soreness, or, if it is a more serious injury, like you've broken a bone, or, ended up having maybe a concussion or things like that. You're going to want to go in and get the proper medical treatment as soon as possible, and continue that treatment until you are fully recovered, or as close to fully recovered as you can get. Insurance companies will use it against accident victims, the fact that they may have delayed seeking treatment for their injuries. And so you want to go and get that treatment right away. And that way you don't give any ammunition to the other driver's insurance company to try to limit or deny your claim. So those are the critical things to do if you're in an accident. We had a show a few months back with attorney Nic McGrue from our office, who runs our personal injury department, where we spent basically an hour-long show going through personal injury and what to do if you're in an accident. I would encourage you to go back and watch that show. These are just kind of three main bullet points that you're going to want to have in the back of your mind if you are ever in an accident, because these are some of the mistakes that we see on a regular basis in our personal injury practice.
All right. Thank you, Sean. With that, we're going to get into a few announcements. Every Tuesday at 2:00 p.m. is the Creative Finance Collective. What is the Creative Finance Collective? That is a membership of lawyers, professionals in the space of creative finance. We've got folks that appear from a variety of different states, from Arizona, Texas, Ohio, California, Alabama, Georgia, Florida. We've had them from everywhere, but we get together, we talk about creative finance, what the laws are looking at like, are there changes in the laws? What are our forms looking like? What can we do better to revise what we have to better serve our clients? But what we're also there to do is to answer questions from you, the listener. So if you have any questions you want to relating to creative finance, make sure to attend. So 2 p.m. Arizona time. We're taking questions for the hour or until we stop getting questions. So if you want us on there longer to discuss creative finance, ask away. It's important that you participate. With that, we're going to go ahead and get into our topic today. We're talking about the top 10 mistakes real estate investors make in raising private capital. And with us to discuss that topic is California attorney Nic McGrue. Nic, how are you?
I'm doing great. How are you doing?
I'm doing well. It's really good to see you. Nic, I know you've been on with us before, but for our listeners who maybe are just joining us for the first time, learning about you, tell us about your law firm, Polymath Legal, what you guys focus on over there in California.
Yeah, so as you said, I'm Nic McGrue from Polymath Legal, and at Polymath Legal, we help real estate investors lawfully raise capital so they can create passive income while generating generational wealth. And so with that, we're helping clients raise capital. A lot of times it's for real estate projects. a few other industries as well, but we're helping them navigate the complex securities laws and regulations around raising capital for their project or the asset that they're trying to acquire.
All right. So let's get into this. What I love about this topic is it just breaks it down as simply as it can be as to what are the top mistakes. And I know you could probably go into a litany, a very long list of all the mistakes folks can make in raising private capital. But why don't we start here? Before we get into the list, why don't you just break down for our listener, what are we talking about when we say raising private capital? What do you mean by that?
Yeah, particularly in the area that I deal with, we're talking about when you're selling a security, and a kind of cheat code for that. It's not always going to give us the right answer, but at least should start raising red flags is if you have passive investors. So if you have investors that are giving you money and they're expecting to sit back and just have you write them more checks back. So they're not going to be involved with the project or the deal, and they're solely investing, giving you the money, and then you take it and run. In that scenario, in most cases, you're selling a security. And so the law says that if you're selling a security, you either have to register that security or have an exemption for registration. And so that's where we help clients. We help them figure out which exemptions might apply and then make sure that they're complying with the requirements of that exemption.
All right. So dealing with passive investors who aren't going to be active decision makers in the process, but are providing money for the investment. All right. So let's break this down. This is our top 10 mistakes that investors can make in raising private capital. All right, so let's go ahead and start in number one. I don't know if we've broken this down in terms of a level of importance. You tell us, Nick, but let's when we say number one, maybe this is number 10, but we'll work our way through the 10.
Yeah, they're in no particular order, kind of in the order of ones that go together a little bit. But yeah, they're all important. So we want to make sure that we don't do any of these.
Yeah, don't screw up any of these. And don't take number 10 or the first one we discuss about to be one where you're like, well, I guess that's one we can kind of ignore.
Yeah.
So give us your first most important rule or mistake to avoid.
So our first one, we kind of almost gave the answer to it, is not knowing you're selling a security. And so I'll see things on, social media, or I'll even get people, inboxing me saying, hey, I've got this deal. It's 50 units in Arkansas. We're looking for, $25,000. Go ahead. And if you're interested, sign up here. And when I look at that stuff, one, I'm not interested in investing if it's somebody that I don't know. But I'll just always look at to kind of see what deals are coming in the market and whatnot. And I'll see that they have maybe a operating agreement or a partnership agreement, but that's the extent of the documentation they have. And so from that, I see that and I say either they don't know that they're selling security or they don't know all the requirements that they need to have in order to sell the security.
Yeah, where I see this happen, it seems like the most in kind of the world of small business is obviously with LLCs or mom and pop limited liability companies. When the typical investor hears the word security, they think Apple or Microsoft stock, right? Okay, well, that's obviously a security, but the question is what else is? And oftentimes, depending on how you're doing it, it's that membership interest that is the interest that you own in a limited liability company can or cannot be a security depending on factors. Is there like an easy test that you like to apply for somebody to just know, okay, this screams security or not? Is it really this passive investment that you discussed previously?
Yeah, so if there's passive investments, that's the first kind of hurdle that I look at that makes me say, okay, here's some red flags. Let's dive into this more. So if we see that it's passive, then the next test we use is actually a legal test from a Supreme Court case, and we call it the Howey test. That's Howey. And there we say if it's an investment of money into a common enterprise with an expectation of profit, primarily from the work of someone else. So investment of money, common enterprise, expectation of profit, primarily from the work of someone else, then that is an investment contract, and most investment contracts are securities. And then we can get deeper from there. But yeah, those are the two initial tests that we go through and we look at.
So, Nick, similar to you, where you're getting kind of, these emails or solicitations, we represent a lot of real estate investors. And so I'm fairly active in different, social media groups with real estate investors, and, they're investing in real estate. And I see these posts quite regularly where it says in need of a PML, which stands for private money lender, and, willing to offer X%, return, or, and they have kind of the terms in there and that type of thing. No disclosures regarding securities or otherwise, in the post or the solicitation. And I think a lot of times, people think, well, it's a loan, it's not a security. So can you talk to us about whether a loan is a security, or if it is, like, when does it qualify as a loan? When does it qualify as a security, or when does it qualify as both,
Yeah, so the SEC doesn't generally distinguish. So debt can still be a security. So you typically, when we're looking at investments, there's either debt where it's money that's owed, or there's equity where you're part of the team. The SEC doesn't make a distinction between the two of those in most cases. So debt in and of itself can still be a security. And to determine that, we go back to, first, is it passive, which debt typically is, and then we dive deeper into the Howey test. One thing to keep in mind, though, as I said, those are the first two inquiries that we do. There are other exemptions or exclusions, and there's some scenarios where sometimes it fits all the tests where it says this should be a security, but the SEC just says, you know what, we're just not going to call this a security anyway, even though it fits everything. So yeah, I've seen many of those posts you're talking about as well, and one I always recommend against, just don't do that. And the big reason is because, like you said, there's no way that you can give all the disclosures you need to give in a social media post, or if you do, it's going to be a post that nobody's wanting to look at. And so I tell my clients, I say, in social media, your goal is to get them to reach out to you, so then you can have a fuller conversation and give them, like, fuller documentation. Your goal is not to get somebody to invest from that post. But yeah, so regarding their private money lenders, I will say that I have seen it done incorrectly a lot of times, but two things that can sometimes save those people is that a lot of times the SEC says a short-term promissory note, so typically 9 months or less. A lot of times that's just going to fall outside of the security realm, even though it might fit otherwise. And another one is if you have it's indebtedness that's secured by a mortgage on a home. And so with private money lending, a lot of times that might fall into one of those two categories. So it could be okay, but I have seen some scenarios where they're doing it not up to par.
Now, you use the term secured, and obviously there's market fluctuations, number one. And number two, I've seen where people have obtained mortgages or deeds of trust against property, but they're not truly secured because, in my view, there was no equity in the property. So is there an analysis that goes into that? Say, hey, I'm going to take a third position lien against the property. And then does the SEC come in and say, okay, well, was this truly secured? Was there truly equity in this property to offer this, third position loan to protect this lender? I mean, how is that analyzed?
I haven't seen them dive into that inquiry. Usually when the SEC is involved, there's so much other malfeasance going on that that's kind of a very surface issue. But I definitely could see them diving into that, simply because while I haven't all out said this, my instinct is that the reason why they have this thing where they're saying this is not a security is because they assume that it's somewhat safer, at least to a degree, especially if it is secured, then it is arguably a little safer anyway.
Right.
And so, yeah, if you're in a situation where we're leaning on a property that has no equity, you don't have any additional safety. And I could see them taking umbrance with that.
All right, Nick. So the first mistake is not knowing you're selling a security. Give us number two.
Number two is not knowing your business plan or your financials. So I'll get clients that come to me and we will help them navigate which exemptions apply and draft the disclosures and things like that. And they'll say, okay, great. So, what return should I give to investors, or what should I do here? And I say, whoa, you are asking the wrong person. I see a lot of this anecdotally, so I may know a little bit more than the average person, but I'm a lawyer. I'm not a real estate operator. And so I tell my clients, I'm like, you are the one. You're telling me the vision and the goal, and I'm trying to help you do it lawfully. And some clients, or at least new clients, will come thinking, oh, I got a securities lawyer, they can handle all this. And in most cases, you're probably not going to want your securities attorney to handle that stuff, because that's likely not their area of expertise. And I can say for me, that's not mine for sure.
Well, it sounds like if you get that question, that's a telltale sign that this might be the investor's first rodeo when it comes to raising private capital, I'm guessing.
Yeah, and that's when I'm asking a lot more questions, saying, okay, let's slow down a second. Let's think about this here. Who's helping you? What is your plan? And letting them know, hey, you're taking somebody else's capital. That's a big responsibility you're taking on. And you want to make sure that you want not only have a plan in place, but know that plan, have backup plans, know the financials, know when things are off course and things like that. And so, yeah, a lot of times in that scenario, I'll advise them to slow down a little bit, do a little bit more homework, maybe find some more partners or mentors or something like that, so that they can iron those things out, the business part of it out themselves.
Now, this is a mistake I would imagine is not just exclusive for the GP, the general partner, or the person putting together the project. I could see passive investors making this mistake as well. Is that something you see also?
Yeah, and we do sometimes review documents for clients that are just looking to invest. They're not the operator, but they're saying, hey, I'm about to spend 100 grand, 200 grand. Can you look through this? And one of the things that I first ask them is, I say, what makes you excited about this, or what makes you interested in investing in the first place? And sometimes they'll say, I know the neighborhood, or I know that market, or I know that specific asset. And then sometimes they're just like, oh, it seems like the numbers that they're telling me seem great. And I say, well, let's take a second here, because that's just a projection and there's no guarantees in any of this. And so we need a little bit more than just the numbers looking good. We want to know, what's behind it that's making those numbers look good, and what's going on that's making us believe that those numbers might become true.
And you may have already answered this, but it sounds to me like the only cure for a client who comes to you and is asking that question is that they just need more experience. They just need to be with better mentors or longer with mentors, because clearly they haven't thought through the long-term end game of the project.
Yeah, or they need more people on their team that have those skill sets that they're missing, or the experience that they're missing. Yeah.
All right, so that's not knowing your numbers or your business plan. Give us number 3.
Number 3 is assuming everything will go perfect. So part of that ties in with the business plan and the numbers. But I'll see, again, I am not the expert in this at all, but I see a lot of deals. And so, if I see somebody right now that's doing, a value add deal on an already built asset, and they're thinking they're going to have, 28% IRR. Right now, what I see, and again, I'll tell them that it's anecdotal, but right now I'm seeing anywhere between like maybe 10 and 18%. So if you're at 28%, that's going to raise some flags to me to say, okay, what's so unique about yours that you can do 10% better than kind of the best deals that I'm seeing? And a lot of times it's because the assumptions they have in their projections are just that everything's going to go perfect. I'm going to be able to raise all the rents, and everybody's going to pay all their rent on time, and our vacancy is going to be at 98%. And that just doesn't happen in most cases. And so assuming that everything's going to go perfect is a fatal flaw. And I'd say you want to take it further, and you almost want to assume, and at least assume that most things go bad. How are you looking? Or assume that those things that you're afraid of that could go bad, what do we look like if those actually go bad? Does it still at least still make some sense? Because if not, we might want to either have a backup plan, or this might not be the deal to enter into.
Now, is this usually a mistake that you see, like the last mistake, among inexperienced project managers, basically?
Yeah, it's lack of experience. If I saw somebody that's very experienced doing this stuff, then I'm not going to be thinking that it's a mistake. I'm going to be thinking that it's malfeasance, that it's kind of knowingly. Because after you've done a few deals, you'll very quickly learn things don't go perfectly. And so if you're modeling your next deal that it's going to go perfect, that's going to be even more of a problem, I'd say.
All right, so that was mistake number 3, assuming everything will go perfect. We live in a fallen world, and nothing is perfect. So plan accordingly. Give us our next mistake.
Next one is taking action before you know which exemptions you're going to use. And the big issue that comes involved with that is that some exemptions allow you to advertise and to get new investors that you've never met before, while other exemptions require that you have a pre-existing substantial relationship with all of the investors. And so I've seen scenarios where, going back to social media again, which is why as a security attorney, I'm not a fan of it for security purposes. But I've seen scenarios where people will be in those Facebook groups talking about a deal they have, telling the projections, telling the return metrics, and asking people if they're interested in investing. And then a week or two later, I have a meeting with that person. They're like, hey, I've got a new deal. And I'm like, wait a minute, I just saw this deal and you already advertised it. And they say, yeah, but I'm just going to have friends and family, or I'm going to use the friends and family exemption. And I say, no, that's not an option anymore, because what you did, I would say that that's solicitation, and the friends and family type exemptions don't allow solicitation. And so now that operator has lost out on the ability to use the exemption that they otherwise could have used and probably would have been sufficient for their deal. But now they're pigeonholed into other exemptions because they've taken actions that make them non-compliant with the ones that they might have used.
Okay, so let's break this down. This is interesting, because of course this is the fault of literally every entrepreneur from the beginning of time, that they might just get excited about a deal and start talking about it, right? So that's super easy to do, but it sounds like what you're saying is some of this stuff can't be unwound. We can't go back and fix it. If you go too far, you've committed yourself. So and once you've committed yourself, I think if I'm understanding it correctly, like on a solicitation, you can't go take advantage of other exemptions that would have been more beneficial to you.
Potentially, yeah. And so one thing to clarify, I'm not just talking about saying, hey, I've got a new project or I've got a new deal and being very generic. I'm talking about getting into the specifics and asking who's interested, who wants to invest. But yeah, so their Regulation D, that's an exemption that works very well in real estate. Part of it is because you can raise an unlimited amount of capital from an unlimited number of investors, and you're not having a whole lot of interaction with the SEC or escrow companies or other third parties. So you can get it together fairly quickly. And so within Regulation D, there's two big ones that are used, 506B as in boy and 506C as in cat. With 506C, all of your investors must be accredited. And simply put, that means that they're high income or high net worth. So if we're talking income, and an individual, they make $200,000 or more. And for net worth, we're talking that they have $1 million net worth, excluding their primary residence. So high income, high net worth earners. With those people, the SEC relaxes its requirements a little bit because they can withstand a bad investment a lot better than people that don't fit into that category. And so with under 506C, if you have all accredited investors, so all high income, all high net worth, then you're able to do general solicitation or advertising. Obviously, your advertising has to be truthful and not misleading, but you're able to solicit and get new investors as long as they're accredited. Contrast that with 506B. That one allows you to raise an unlimited amount of capital from an unlimited number of investors. In addition, you're able to raise from 35 unaccredited but sophisticated investors. So all of your investors don't have to be accredited. But with 506B, you must have a pre-existing substantial relationship with all of your investors, and you cannot advertise. And so if you're planning to do a 506B raise, and then you had posted on Facebook a few days earlier, hey, I've got this deal, here's the metrics, here's the returns, come invest with me. Well, you've now done a solicitation, and so now you're not going to be able to avail yourself to 506B anymore.
So what do you do? Is there even a way in that circumstance? Because you don't know who your audience is in a Facebook group, right? You've just talked about the deal and you said, if you're interested, DM me, kind of thing. That's what you see. Is there any way to know for certain whether you've complied with any of the exemptions or requirements when you do basically a full solicitation to a group like that?
No, not really. That's again why I say I'm not a fan of, because clients always ask, what can I do on social media? And I say, do as little as possible because, and I again tell them the goal is to get them interested in your general business and your buy box and your kind of investment plan, but not in specific deals. Your goal is to start building, to use that as kind of the first place where you're building a relationship with them. And I say that because one, most people are not going to invest on that random DM they get anyway from the person they don't know. They're typically not going to invest. So you want to be building relationships with your investors in the first place. But two, if you're building those relationships and not in the way that you're starting it is not based upon some deal that you're pitching or anything like that, when you're building that relationship, that can, assuming you don't have a deal in place, that could be the start of your pre-existing substantial relationship, which would allow you to have them in a 506B raise, or if they're accredited, they could also be in your 506C raise as well.
All right. So know your exemption before you open your trap on Facebook or anywhere else. Give us our next rule.
Next one is, and I saw this actually in your intro, using a JV as a securities exemption.
Yeah, Sean likes this one.
Yeah, a lot of people, I see this a lot. And the tough part is I'll tell clients, I'm like, you can't do that. And they're like, but I just saw this. And I said, yes, I have seen numerous of them as well. That doesn't mean that it's the right way to do that. So a joint venture, as you know, essentially it's a partnership in some form. And a lot of people will create a joint venture saying, oh yeah, we're all JVs together. So there's no passive investors. We're just partners. We're JV partners. And I say, okay, explain each person's role. And usually what happens, there might be 5 to 10 JV partners and there's 2 or 3 people doing all the work. And I say, that's not a JV. That is you trying to get around securities laws. And the SEC is going to see right through that, just as I quickly saw right through that.
So Nick, this is one of my biggest pet peeves because I see this out there in the investor space on a regular basis. And it's not just securities issues. I mean, you have these investors that are running around with joint venture agreements and trying to whitewash all kinds of improper conduct. They want to practice law without a license using a JV agreement. They want to, be a real estate broker, a mortgage broker, sell securities, without going through the hurdles of, proper licensing and things like that. So talk to us in the securities realm, because I do think there is a time and place for a JV agreement. And it is proper. It is a partnership agreement. My position is always, okay, the right way to use a JV agreement, if you're going to do it, is both, or if there's more than one or more than two, all partners on the JV agreement should also take an actual interest in the transaction. And then the JV agreement, so they should be, on the purchase contract, on title to the property. And then the JV agreement basically just defines their relationship. So instead of forming an LLC operating agreement, you're going to have a JV agreement, which is a little, simpler, doesn't require, formation, with the state, anything like that. And it's, like you said, a partnership. So tell me, in the securities realm, how is a JV agreement properly used?
It's generally not in the securities realm, at least for the securities purposes. You could have a scenario where you have a proper JV, and then underneath that, there's capital being raised somewhere, and you have the PPM and the other documentation that you need. But as for strictly security purposes, there's not a way, that, at least that I've seen or used it. Because typically when I have clients asking about it or saying, yeah, we need a JV agreement, I say, yeah, that's not a JV. That is you trying to get around securities laws, and it's not an exemption from securities.
Now let me ask you this. Let's say that I own a piece of property. I'm getting ready to develop it, and I am looking for people to partner with me on that process. And so I'm willing to convey, say, a 30% interest in the actual real estate to a third party. So I say, okay, I'm going to sell you a 30% interest. You're going to pay X amount of dollars for that 30% interest. And then we're going to, split profits, et cetera, blah, 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 blah. And you maybe define it in a JV agreement, and then you sell off that 30% interest. Is that a security? Are you selling a security at that point? Most
likely, yes. So
Okay.
your JV partner would need to be active. So the example that I give that could be a lawful JV partner is, maybe I own a piece of land, you own a construction company and Andy Andy has investors and is able to raise capital. The three of us together could make a great partnership and build an awesome project. And without the three of us or someone like us, the project may not get made. And so all of us are crucial and important to this deal. And we're all bringing our various skill sets to the deal and are going to be active in the spheres that we're good in. That would be a legitimate JV. And sure, there would be some security implications that would need to be addressed, but that specific JV itself, everybody's active, everybody's actually bringing material skills and actions to the project. And so that likely would be an okay JV.
So if the JV agreement, though, basically says that one person to the on title to the property is going to run the whole project, even though you've given your other JV partner an interest in the actual real estate, it still is likely going to be a security because they're, still passive?
Most likely, yes. Yeah.
So in that case, it may be better to basically give them like a mortgage or lien interest against the property, as opposed to, an ownership interest with a JV agreement.
Yeah, it obviously depends on the specific setup, but yeah, the mortgage and lien could be a way to take it out of the securities conversation altogether.
Interesting.
All right, Nick. So that was number 5, using a JV as a securities exemption. Give us number 6.
Yeah, this one is if you've actually figured out what exemption you want to use and know what you're doing, you've got to actually do the requirements. So not following the requirements of your exemption. And so I've had clients, we mentioned earlier about 506B. That's the one where you can't do any solicitation. And I've had clients where they say, yes, I'm going to do 506B. We're not going to do solicitation. It's only going to be people with whom we have a pre-existing substantial relationship with. And then they start asking, wait, so what can I post on social media? And there, my answer is nothing at all. But I've also seen scenarios where somebody will post on social media saying, oh yeah, we are trying to raise capital. Here's the deal. Here's all this. And then people will rightfully ask, oh, are you doing a 506C raise? And they'll say, oh no, it's 506B. But I know all of you because you're in this Facebook group. No, not going to work. So with 506B, you're required to have a pre-existing substantial relationship. And the SEC hasn't done us a favor in helping us fully define that. But essentially what I tell clients is that you need to understand whether they're sophisticated or accredited and the reasons why. You want to understand what their financial background is, what their investment experience is. Have they only done just stocks and bonds, or have they done other types of alternative investments before? So you want to be having a deeper understanding about their financial background than just we're in the same real estate Facebook group, because that's not going to be substantial.
Okay. So a substantial relationship could mean, obviously means people you've done deals with in the past. Would it include that?
Most people likely would be included. Yeah.
Okay. But it doesn't have to be. So a substantial relationship could include family, for instance, or folks that you just happen to know well, but haven't been economically tied through a business relationship.
Assuming that I still have an understanding of their financial understanding, that could work. It also could be somebody that I meet at a meetup, and then we have coffee together and we have those deeper conversations where I'm getting to know what their experience is. That also could create a substantial relationship as well.
Is there a way you like to coach clients to try to remember these exceptions other than just rogue practice? I mean, because again, this sounds like a mistake that's very common for the inexperienced.
Yeah. So when I say don't do this alone, go use your attorney. Even if it's not me, make sure you're working with an expert. But regarding the substantial relationship, I often tell clients, you want to meet them one time and say, hey, my name's Nick. I invest in value add deals, $100 or more in the Sun Belt. These are the types of deals that I like to invest. What are you interested in? So just a very surface level, not getting into any specifics, but just kind of introducing our business plan, general business plan, and objectives. Then the next meeting you have with them, you start getting into, okay, what have you invested in before? What's your financial background? Do you have any licenses or education based upon finance or something like that? And then that third meeting, I say that's when you can maybe start doing the actual pitch. Obviously, it depends on which exemption you're using as well. But yeah, that's how I coach clients, is to essentially have 3 meetings and to have 30 days in between the first and second. And part of this, I will say that it is probably a bit on the conservative side, but the SEC hasn't really told us truly what it is. And so I'd rather be on the conservative side, where I feel very confident that they're well within the bounds of the SEC, versus being a little less conservative and we're not really sure whether we're within it or not.
Well, and it sounds like, to be effective with what you're talking about, is the investor, the client, needs to be thinking about cultivating these relationships well before they're trying to decide on a particular deal. Because when you're talking about 30 days, 60 days, 90 days, these aren't things that are all going to take. You're not going to be able to prove or show what was not a substantial relationship, for instance, prior to a deal, and then get all that and establish that in a matter of 2 weeks, right? I mean, this takes time to show that you've cultivated it. So you need to be thinking about deals well off into the future, it seems to be.
Yeah, absolutely. And another thing that I tell clients is to have a system of when you meet somebody, to where within your firm or company, you say, this is what we do every time. We met them out, we email them, this is the email template we use. Then we met them, this is what we talk about at the first meeting, this is what we talk about the second meeting, this is what we talk about the third meeting. And that goes further again in substantiating and documenting that you indeed do have that pre-existing substantial relationship. And it will be helpful for you to say, yes, this is what we do every single time that we meet somebody. And here's our documentation that actually shows that as well.
All right. So know the requirements of the exemptions that you're using. Give us our next big mistake. This seems like this one flows right from the last.
Yeah. Doing it alone. So I have clients that are single operators and can be successful, but it's a lot of work. And especially for newer clients, they often don't realize how much work it is raising the capital and investor relations. They're working on taking down a deal and getting the loan and closing all that. That in and of itself is a lot of work. And then you add on the layer of dealing with, hundreds of thousands or millions of dollars of other people's money, and all the investor relations that goes with that, all the regulations that I'm helping them be compliant with. And so a lot of people don't realize how much work it really is. And so the people that I see that are more successful, they either have a good team, or at the very least, they have lots of good systems and processes in place, and employees or team members that are going to be handling those other steps. Because I always say, real estate is a team sport. It really is a lot more work than, all the TikToks and YouTube shows might have you thinking.
Does the amount of money in question or that you're raising change this dynamic at all? Is there any amount where somebody by themselves could maybe go in alone and do this, or in your estimation, if you're going in alone, you're setting yourself up for failure, no matter what the amount?
Yeah, I mean, like I said, I have clients that are solo operators. I mean, they again have employees, but you can be successful solo, but it's a lot of work. And so I wouldn't say it's so much the amount of money, but the number of investors. And because this is one thing that I tell clients, I say, you want to try to get the bigger checks. You'd rather have one check for $1 million than 10 checks for $100,000. It's the same amount of money, but in one scenario, you're getting one phone call when things go bad or there's questions. In the other scenario, you've got 10 phone calls you've got to deal with. So I'd say it's more of the number of investors that you have. And then I'd say another thing that would make it more difficult to go alone is either the size of the project or kind of the difficulty. If it's not at your standard close and there's some funky things that we got to work out, then that, again, if you're the operator, that's you who's going to have to be the main person, at least directing your professionals of where to go. And so the more complex the project or the asset, you're going to want some help. And then also the more investors that you have, you're going to want some more help as well.
So question for you, and just to kind of follow up on what Andy was asking about, dollar amounts and things like that. Is there kind of a dollar amount that the SEC looks at and says, oh, okay, well, people can invest that amount and you don't really have to do disclosures or anything like that? And an example would be, let's say I bought a Airbnb, right? and now I need to furnish this Airbnb. And so I go out and I solicit a $10,000 loan from somebody. It's not going to be a short-term loan, but I'm going to, say, I'm going to guarantee you, 12% a year on your loan until, for 5 years, then I'll pay it all back or something like that. Right. So that's probably a security, but it's $10,000. And, I know, Nick, you're not cheap. And so, your fees, are expensive, any SEC attorney, and rightfully so. So is there an amount that the SEC kind of looks at and says, oh, okay, well, that's okay? Or would that be a security and technically it needs to get, all the proper documentation in place?
Yeah, that would still be a security and technically would need the proper documentation in place. And so, yeah, in those scenarios, I either say, don't talk to me at all and don't let me know at all what's going on. There's been, I can't think of any specific, but I know there's been times where we were able to genuinely and materially, it wasn't that small of an amount, but get the person who was bringing the capital to have them have an actual meaningful role in the project. And we said, you have to do this, otherwise it's going to cost a lot more money, or we're just not going to be able to do it. So, if you have smaller amounts, then that's when you want to think about, can this person and will this person actually, can they bring something to the table of this deal besides their money? And if so, is there a way we can make them an active material participant in this deal, in which case they're not expecting a profit primarily from the work of someone else, which can take it out of the securities realm. But yeah, it's a tough thing to deal with because, even right. You said 10,000, that's too much. But even if you're looking at like 100,000, 200,000, I tell clients a lot of times to make the cost of me and an accountant and the other things you're going to need to do it right, you probably need to be raising 300,000 and really closer to 500,000, just because otherwise your expense to capital raise ratio is just going to be way out of whack.
Yeah. All right. So don't do it alone. Let's go into the mistake number 8. Give that to us.
Yeah. Next one is not communicating with investors regularly. So if you've raised the capital, now you have investors that you're beholden to, and you want to communicate with them regularly. I tell clients to develop a cadence, whether it's monthly or quarterly. You want to communicate with them regularly, because a lot of times when there's issues, it's because obviously if the deal goes bad and there's money being lost or what have you, investors are upset. But a lot of times when they're contacting the SEC about that is because they think that you're doing something bad or sneaky. And so one easy way to kind of avoid that is to communicate with them very regularly and let them know the good things that are happening and letting them know the bad things that are happening as well. Another thing that regular communication can do in helping the operator is that when there are bad things, if I'm an investor and I haven't heard from you in a year, and then you say, hey, I've got some updates and we have a webinar and you're telling me that there's something bad going wrong, I'm going to be upset and saying, why didn't you tell me earlier and how this happened and what's going on? Versus if you're having quarterly or monthly meetings, then when I get the notice, I'm like, oh yeah, it's just another update. And then also with that, a lot of times, the quarter before things go bad, you have an inkling that things might go bad. And so in that, you say, hey, here's some things that are happening that could, be bad for this deal. Here's the things that we're doing to mitigate and try to stop this from being a bad thing. But just want to let you guys know and keep you informed of all the things that's going on. So if you tell me that in Q1 and then Q3 comes and you say, hey, remember that thing we talked about in Q1? Here's all the steps we did. They still didn't work. So we're having to do a capital call, or we have this other bad news to share with you. As an investor, granted, I know this world a bit more, but a seasoned investor or knowledgeable investor would say, yeah, deals can go bad. And this person, they let me know, they told me well in advance the things that they were seeing on the horizon. I see that they were doing the work to try to prevent it. And sometimes you just can't do that. And this is an investment that didn't go so well. And that investor is probably not running to the SEC saying, Sean or Andy stole my money. They're saying, yeah, this stinks that this investment didn't work out, but that's about the extent of it. And I've even, particularly in the current real estate climate that we're in, a lot of people are having to do capital calls to where, their loans are either becoming due and they're having to refi into today's terms, which are double what they probably got into. And so a lot of clients are having to capital call. And, I had one client that had a capital call and they were very concerned, very scared. And they called some client or investors, and those investors just said, oh man, that stinks. How are you doing? I know this has to be hard on you. And the investor was caring about them when they're saying, hey, investor, we need more money from you because this deal isn't going so well. But part of the reason that happened is because that investor knew, 9 months ago that this might be something that's happening. And now they're saying, yeah, the writing was on the wall way back then. They told me about it. And I know that they're being a good steward of my money. And just the market that we're in is not as strong as it was when we got into this deal.
So you've mentioned having like webinars or I'm presuming, video meetings and things like that. So it's one thing to send an email or a text or something like that when the project's going great. If the project's not going so great and you have to deliver bad news, is there a method that you recommend communicating that, bad news, whether that's, like you said, a video conference, a phone call, a text, email, etc.? What's, do you have a specific recommendation on how to, properly deliver that news?
Yeah, so you do want to have deliver it, at least some form that you delivered it in writing. But I also recommend that there be some sort of in-person, whether it's video or at least a phone call or something, because investors are going to have questions. And if you just send them an email saying, hey, we're losing money, good luck, and don't give them the opportunity to voice their concerns or get their questions heard, again, that's going to be the thing that makes somebody run to the SEC. And whether you've done something bad or not, having an SEC investigation while you're trying to mitigate the market messing up your deal, that's not going to help your deal get any stronger. It's going to be taking more resources away. So yeah, I say that you want to have something in writing just so you have it documented that we did disclose this, we did tell it, but you want to have some forum that allows people to ask questions and get answers to those questions.
All right, Nick, I think one of the key things that you said about that I like and is obviously true, it's cadence. And if you have a cadence to your notice and disclosure, you're really forced to give the good, bad, and the ugly. Some people tend to just talk about the good. Some people are good talking about the bad. It's really just notice of everything going on. And I think one of the biggest things passive investors really care about too, good, bad, or ugly, is that you are being proactive, right? That you're thinking way ahead of time about solving the problem. And if you're identifying it, and of course, if you're doing things in a cadence like you talked about, you're thinking about what's on the horizon, and you can begin talking about that, putting that in writing and answering those questions. Good information. All right. So that is mistake number 8. Give us number 9.
Number 9, slightly related, but probably earlier in the stage. It's failing to make all the required disclosures. The PPM, I shout this from the rooftops. The PPM is not going to sell your deal. It's going to scare people away. And, clients don't like it when I tell them that, because I'm like, yes, it's scaring them away. That's a good thing. But it really is. The PPM is there to inform the investors of what the deal is, who the operators are. And a big part of that is also what could go wrong in this deal. And that's the thing that a lot of clients kind of want to shy away from. But I get sometimes where I'll put in, we call it risk factors in the PPM. I'll put in a risk factor and a client will say, oh, this sounds really bad. Can we change this or can we take it out? And for me, that makes me want to highlight it and bold it and underline it, because to me, if the client who's the operator is saying, oh, this sounds bad, this is going to make people want to go away, then I'm like, yes, let's shout that so that they go away before they write us a check, because we don't want to get somebody that's invested to where there's information that we knew, but we withheld that from them. And if they had known that, they would have not invested. We want to get the no's very quickly, get them out of the way. And yeah, great. There's risks. There's things that are about this deal that may not be great. And if you don't like it, wonderful. I'll keep you on my mailing list and I'll let you know about the next deal. But we don't want to say, oh, there's this thing that's kind of bad about this. I hope it's not going to happen. Let's just not tell them it's probably not going to happen, because we all know what's going to happen. Then it's going to happen. And then we haven't disclosed it. And so, yeah, I get a lot of pushback from clients saying, can we soften this? Or do we really have to have that in there? And when I get that, that really makes me want to highlight it even more, because, the deal is what it is. The risks are what they are. We want to give the investor all that information, and then they can decide for themselves.
Yeah, good information. Disclose, disclose, disclose. We can't say it enough. Pick your area of law, and you want to disclose. All right, so we are to number 10. Give us our number 10. We've all been waiting.
Yeah, number 10, this is one that I see a whole lot. It's paying illegal finder's fees or having capital raisers. So the SEC does not allow you to give transaction-based compensation for selling a security unless you have a broker-dealer license. And so what I mean by transaction-based compensation, essentially we're saying a commission. You can't pay somebody to introduce or get you an investment if their payment is contingent upon the investment being made or how much investment is made. And so essentially it's the commission that we all would want to give. And so I've seen scenarios where people say, yeah, you know, for every $100,000 of investment that you bring, we'll give you 0.5% of the GP or something like that. If that person doesn't have a broker-dealer license, then that is an illegal finder's fee. And I see it all the time, unfortunately.
Now, with a lot of SEC requirements, like we discussed before, you can't really unwind the clock, right? Once it's been done, it's been done. What's the penalty for something like that?
I don't know if it's exactly criminal, but you definitely would be labeled as a bad actor. The SEC would also likely make you give the money back. Also, the deal itself could have issues. You know, with your investors, you took your investors' money and gave it to somebody unlawfully, so there could be some issues with that as well. So I just don't want to do it. And I know this is one that people watching are going to say, wait, I just got an email about that last week. I know you did. I see this all the time. And I can't say enough that, you know, all the stuff that I do, and I'll tell clients this, they don't like this joke, but I say, look, you're going to pay me a whole lot of money to write a whole bunch of long, boring, scary documents. And our goal is that we don't ever look at them again. Because we hope that everything goes well. And if everything goes well, we're not caring about what's in the PPM or anything like that. But if things go wrong, we're going to be very, very happy that we had that. And so similarly with this, people say, oh, but I see it all the time. And I say, great, that's because that deal and things have been going well. But if they are not going well and somebody's calling the SEC and the SEC starts looking into it, you're going to have a very big issue.
Well, folks, those are the top 10 mistakes investors make when raising private capital. Nic, tell our listeners how they can find and connect with you.
Yeah, you can find me on social media. It's at Nic the Lawyer. That's NIC the Lawyer. And also you can reach the law firm Polymath Legal at www.polymathlegal.com. That's POLYMATHLEGAL.com.
Nic, as always, it was awesome having you. Great information. Let's do it again soon.
Definitely. Happy to.
All right. With that, everybody, that is our show. Make sure to join us next week. We'll see you then.
Have a good day, everyone.